Today's Brandon's blog is titled Declaring Bankruptcy, Real Estate Company Loses Challenge on Corporate Bankruptcy Appeal. Brandon writes in the blog below about the recent decision out of the Court of Appeal for Ontario on the appeal made by Medcap Real Estate Holdings, Inc. against the bankruptcy order that the lower court issued. It's very interesting, the thought process and analysis of the Court of Appeal for Ontario, because it lays the groundwork and establishes a blueprint for exactly how you need to take into account certain factors if you're going to appeal a bankruptcy order made against you or made against your company. My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. I hope you can watch until the end of this video because I know you will find it informative. The Brandon's blog below, Brandon first gives an overview of corporate bankruptcy. He talks about what business insolvency is. He talks about the corporate bankruptcy process and the two different ways a corporation or a person can get into bankruptcy. The first way is voluntary, making an assignment in bankruptcy. The second way is involuntary, which means one or more of your creditors go to court on a bankruptcy application, asking the court to make an order putting the company or person into bankruptcy. The threshold is not that high. In order for a creditor to make a bankruptcy application, they have to be owed at least $1,000, and they have to prove that the company has committed at least one act of bankruptcy during the 6-month time period before the bankruptcy application was filed. The acts of bankruptcy are laid out in the Bankruptcy and Insolvency Act, and the most common one is failing to meet its debts as they come due. And that's not just the debt of the party or parties that are going to court asking for the bankruptcy application, but in general, the company has ceased meeting all of their liabilities as they come due. Brandon then goes on to talk about the two types of corporate bankruptcy proceedings. The first type, if the business of this company is both insolvent and not viable, then what you're looking at is a liquidation of the assets, a liquidation bankruptcy, where the assets will get sold off either as a business unit or piecemeal to whoever wants them. The second kind of bankruptcy is what the media always describes as bankruptcy protection. And what that is the company files either under the proposal restructuring section of the Bankruptcy and Insolvency Act, or if it's a larger company, under the Companies Creditors Arrangement Act. And seeking bankruptcy protection is for a company where the business or the bulk of the business, maybe not all of it, is still viable if you cut away the bad parts, and the business is currently insolvent, but it can show how it has financing lined up, and if the restructuring process works, the company will return to profitability. And that's called a restructuring. So the two kinds liquidation bankruptcy or a restructuring under Canada's insolvency statutes. Brandon then answers a question we're asked many times. Does corporate bankruptcy affect personal assets? And the answer is not necessarily directly, but it might indirectly. So if you think of an investor or shareholder who's put money into a company and the company goes bankrupt and there isn't enough money from the liquidation to repay those investors, they will lose some personal assets, whatever money they used to invest in or buy shares of the company. Or perhaps directors have a personal liability because of certain statutory obligations that the company couldn't pay. And finally, perhaps the entrepreneur who owns the company had to personally guarantee the bank loans of the company. And during the bankruptcy liquidation, there's insufficient funds to repay the bank in full. Whoever personally guaranteed the bank loan will be on the hook out of their personal assets to make sure that the bank is fully repaid. Then Brandon goes on to the MedCap case, which is very interesting. I will just summarize it here. MedCap had a bankruptcy application against it, and the court held that the evidence showed that MedCap was not generally paying all of their debts on time and had committed an act of bankruptcy during the 6 months before the bankruptcy application was filed, and therefore made a bankruptcy order against MedCap. MedCap appealed, but on the appeal, they admitted that they were not paying their debts generally as they came due, and they did owe at least $1,000 to this one creditor. Actually, it turned out to be $250,000, but they argued that, and MedCap's position was that the lower court judge should have used his discretion and not issued the bankruptcy order. Well, the Court of Appeal listened to these arguments and dismissed all of the arguments. The Court of Appeal found that MedCap was not able to pay all of its debts as they come due, and the Court of Appeal said that the Canadian insolvency process is to be fair to all creditors and has to take all creditors into account. And the fact that they made a settlement with the creditor whose bankruptcy application survived does not mean that they're meeting all of their debts generally as they come due. So the Court of Appeal dismissed that argument. Next, MedCap argued that the bankruptcy application was for an improper motive. The Court of Appeal held that a motive is a question of fact, and they found no facts in MedCap's support of their claim that the bankruptcy application was made for an improper motive. And third, MedCap argued there was no purpose for this bankruptcy. The Court of Appeal stated that because the bankruptcy is to treat all creditors fairly, and because MedCap admitted that it wasn't paying its debts as they came due, and that it had committed at least one act of bankruptcy, the only way MedCap could have shown there was no purpose for the bankruptcy is to show the court that they had a real restructuring plan ready to go, that they had the necessary financing to support the company through its restructuring, and that the majority of creditors needed in order to support and approve the restructuring plan that creditor support was in place. MedCap didn't come to court with that evidence. Rather, they just said, leave us alone and we will work it out. Well, that was not good enough for the lower court, and the Court of Appeal agreed that the bankruptcy order should have been made because there is a real purpose for this bankruptcy. So I hope you can read the entire blog below, because I know you will get value from it. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.